Hello, my name is Alexis Clay, and I'm a staff attorney at the Pro Bono Project. We assist low income members of the community and seniors in Jefferson and St. Bernard parishes with civil legal issues. Today, I will be discussing wills in Louisiana, and hopefully, what I tell you will help you determine whether or not you need to have a will done. A will basically serves as your voice after you die. It makes your desires known and ensures that they'll be carried out upon your death if the will is done correctly. It can name a tutor for your minor children. A tutor is Louisiana word for guardian. It can create a trust, and it determines how your estate will be distributed. In Louisiana, we have two types of wills, holographic and notarial. The holographic will must be entirely written, dated, and signed in the handwriting of the testator, and they must sign at the end. The testator is the one making the testament or the will. You cannot go online and print out a template and sign and date it, or it will be held invalid. You need to write it yourself. The date must also be reasonably ascertainable. That means that something like I'm writing this on my 50th birthday, it could be considered reasonably ascertainable, but the safe bet is to just put the day, month, and year. The notarial will is the suggested option because it's more legally sound and more difficult to challenge. The requirements for that are that the testator must sign every single page and again at the end. They must sign in front of two witnesses and a notary, and must declare in front of those two witnesses and the notary that this is their last will and testament. The will must also contain an attestation clause, and that's the clause saying what the witness is attesting to. And it's important to note that one simple mistake could invalidate the entire will. So it's very important that you read over it and that you know what's supposed to be in there, because you can't just trust the attorney who drafted it for you, because attorneys make mistakes too. I've had to tell plenty of families that the will is invalid and the property will have to devolve by intestacy, and that's what we'll discuss next. What happens if you don't have a will? So when you die with a will, that's called dying testate. And dying without a will is called dying intestate. And when you die intestate, Louisiana law determines who receives your property. The rules are different for community property versus separate property. Community property is property accumulated during the marriage, and separate property is property accumulated before marriage or received via inheritance, or property that's given to one spouse only during marriage. For community property, your descendants would be first in line to inherit. Your descendants are your children or your grandchildren. But this will be subject to a spousal usufruct if you have a surviving spouse. Usufruct is the right to use the property, usually until death or remarriage in the case of a usufruct. So in this case, your spouse would be what's called the usufructuary, the person who has the usufruct and the right to use the property. And your children or grandchildren will be what's called the naked owners, and they will get full ownership and full rights in the house or any other property after the usufruct ends. If there are no descendants, then your spouse will get the property outright. If you do not have a surviving spouse or descendants, then the property is treated as separate property. Separate property goes to your descendants first, and if there are no descendants, then they look to siblings and parents. If you have both siblings and parents living, then your parents will get the usufruct, the right to use the property, and your siblings will be the naked owners of the property. If there are no siblings or parents, then it goes to your ascendants, your grandparents. And if there are no grandparents, then the law looks to other relatives and tries to find the closest relation to inherit the property. Can you pick whoever you want to inherit? The answer to that is yes and no. It depends. That's the typical legal answer. You can pretty much leave your property to anyone in the world that you want to inherit it, but if you have a forced heir, that forced heir is entitled to a portion of the estate, even if you left all of your property to someone else. A forced heir is any child of the deceased who is under the age of 24, or a child of any age who is permanently incapable of taking care of themselves. Please note that even after your child has passed the age of 24 as an able-bodied adult, they may have some sort of accident that leaves them permanently disabled and unable to care for themselves. Then they could be considered a forced heir and would be entitled to a portion of your estate. That portion is called the forced portion. A forced heir can be disinherited in a will, but only via certain circumstances. For example, they have threatened or attempted to take your life, or for the most popular reason, and that is they have not communicated with you for a period of 2 years or more. So if you want to disinherit a forced heir, you have to be very clear and concise in your will and say that I am disinheriting Susie because she has not spoken to me in 3 years. Be very clear with your reasoning and very clear with who you are disinheriting. As a side note, I want you to be sure that you don't have a witness or a notary receiving something in your will. That gift will likely be deemed invalid. It's in your best interest to have completely disinterested parties be witnesses and notaries to your will. You can include pretty much anything you own in a will. However, a will cannot determine who receives insurance or retirement benefits or things of that nature because they are beneficiary based. So be sure that you are keeping your beneficiaries up to date so that you have who you want to receive that in place. If you or someone you may know needs to have a will executed, please feel free to contact us. You can go on our website, www.probono-no.org, and find an application for services and fill that out and return it to us as soon as you can. Or you can give us a call at 504-581-4043, and we can get your information and mail you out an application. We're located at 935 Gravier Street, Suite 1340 in New Orleans. And if you have any questions about this video, I can be reached at that same number, and my extension is 209. And again, my name is Alexis Clay. I hope this video has been helpful and that you've learned something about wills that can help you decide whether or not you need to have one done. Thank you.